Good evening, everyone. My name is Jim White. I'm the Dean of the College of Arts and Sciences here at the University of North Carolina at Chapel Hill, and I would like to welcome you to this afternoon's Abbey Speaker Series event, Interpreting the Second Amendment. The Abbey Speaker Series is hosted by UNC's Program for Public Discourse, which seeks to build our students' capacities for debate and deliberation, and to foster a culture of constructive dialogue about issues of natural importance at UNC and beyond. 4 times each year, the Abbey Speaker Series brings together experts from different fields and disciplines to showcase productive dialogue on timely issues across a range of perspectives. On behalf of this university and the college, I would like to thank the Abbey family for helping us bring such an important programming to campus. I would also like to express this evening my gratitude to Sarah Truhl, who has served as PPD's faculty director for the past 5 years. Sarah has overseen the development of not only the Abbey Speaker Series, but also PPD's other public outreach and campus programming. These are difficult times in which to pursue civil discourse, and the university and the college and I am deeply appreciative of Sarah's leadership. And if you want to give her a round of applause, now would be a good time. Thank you. This evening's topic, Interpreting the Second Amendment, is certainly an issue where civil conversation is necessary. The Second Amendment, which protects the right to bear arms, has been part of the United States Constitution for more than 2 centuries. However, its meaning has been hotly debated by lawyers, politicians, and many others. Meanwhile, the Supreme Court has recently delivered several high-profile rulings about gun rights. Tonight, we will hear from legal experts who will discuss the history of the Second Amendment, the merits of recent court rulings, and the future of Second Amendment jurisprudence. I want to remind the audience that the views expressed by panelists do not necessarily reflect those of the university or sponsoring programs. Thank you all so much for joining us tonight. I will now turn things over to Sarah.
Excellent. Good evening. Thank you, Jim, and thank the rest of you for your lovely applause. It's very much appreciated. I've enjoyed my time immensely with the Program for Public Discourse. As faculty director for the program, it's my distinct honor to introduce our wonderful panelists for this evening. We are here and gathered with a bunch of legal experts who have different perspectives on the Second Amendment, and we're really looking forward to this conversation tonight. Starting on the far side there, Joseph Blocher is a Lanty L. Smith, class of '67, distinguished professor of law at Duke Law School, where he co-directs the Center for Firearms Law. His current scholarship addresses issues of gun rights and regulation, free speech, the law of the territories, and the relationship between law and violence. Amy Swearer is a senior legal fellow in the Edwin Meese III Center for Legal and Judicial Studies at the Heritage Foundation, where her areas of focus include the Second Amendment, overcriminalization, school safety, and mental health policy. In this role, she runs the Heritage Foundation's Defensive Gun Use Database. Our moderator for this evening, Matthew Kotzen, is a professor of philosophy at UNC and the chair of the philosophy department. His research primarily focuses on issues of epistemology and the philosophy of science and the law of evidence. He received his JD with high honors from the University of North Carolina School of Law in 2021. We will take questions from the audience at 6:30, and during this time, please raise your hand and someone will bring you a mic to ask your question. If you enjoyed tonight's event, which I expect you will, please consider signing up for our listserv for the Program for Public Discourse by clicking on the email icon at the top of our website. This is the most excellent way for you to be informed of our programming moving forward, and we appreciate you also knowing what our affiliates are up to, our student programming, and other workshops that are available. And now I turn the conversation over to Matt. Thank you.
Great. Thank you so much, Jim. Thank you, Sarah, and thank you to all of you for being here. So I thought we'll have a discussion tonight for about 55 minutes or so until about 6:30, and then we'll open the floor to some questions. I have a question or two from the Zoomers, and then we'll have some questions from the audience as well. So I thought it'd be a nice place to start with the text of the Second Amendment itself, since that's what we're going to be discussing for a lot of our time together tonight. I thought it'd be useful to kind of have that as a focal point and also to have some shared vocabulary, some shared language surrounding the Second Amendment. So I'm sure much of this is familiar to many of you, but the text of the Second Amendment is divided into two parts or two clauses. The first part is often referred to as the prefatory clause because it's a sort of preface or introduction to the substantive right that's announced in the second part or clause of the amendment, which is often referred to as the operative clause. So the prefatory clause is a well-regulated militia being necessary to the security of a free state, end of prefatory clause. Here's the operative clause. The right of the people to keep and bear arms shall not be infringed. So those are the two pieces. That's, I think, shared on all sides. The more controversial question, which I expect that we'll get into in some of our discussion tonight, is what exactly the relation is between those two clauses. Whether the prefatory clause restricts in some way the scope or operation of the operative clause, or whether the prefatory clause is just there to announce some kind of purpose or goal of the operative clause without actually substantially impacting the contours of the operative clause. So that's what I wanted to kind of start with. And one interesting anomaly fact about the history of American jurisprudence about the Second Amendment is that for over 200 years from when the Second Amendment was ratified in 1791 until 2008, there really was not a lot that we heard from the Supreme Court about the Second Amendment. There was almost total silence. There were a few cases, Miller in 1939, but even during a period of really intense scrutiny by the court, by the Warren Court in the 1960s, where they were going through kind of clause by clause through the Bill of Rights and trying to decide exactly what each one of these clauses meant and whether it was essential to our scheme of ordered liberty and whether it was incorporated against the states through the 14th Amendment Due Process Clause. Even then, there was almost nothing from the court about the Second Amendment. So the question I wanted to start with for both of our panelists tonight is sort of why that is, why the court for over 200 years seemed to avoid basically any meaningful engagement with or interpretation of the Second Amendment, even while it was deeply engaged with investigating quite carefully the contours of other individual rights and other ways in which the Constitution provided a protection for individual rights against both state and federal power. Joseph, could you?
Sure, I'm happy to start. Let me start actually by thanking all the organizers and all of you for being here. Really looking forward to the conversation. It's a great question to start with because it sets up like an obvious puzzle. These 27 words have been in the Constitution since the Second Amendment was ratified in 1791, and yet for 2 centuries there's not a single case, not even just Supreme Court, any federal case anywhere in the country striking down a gun law on Second Amendment grounds. There's a lot of sort of like silence in that respect, and so you might wonder, well, why? 3 partial answers here, or a couple partial answers. One is that it took the court a while to get around to a lot of the other amendments too, as Matt's question sort of teed up, right? I'm looking down here in the front row. I've got 2 First Amendment experts looking at me, Professors Ardia and Papandreou in the law school, who will tell you the First Amendment didn't come online really until the 19-teens, 1920s, right, after it had been in the Constitution for a good 130 years. I see here Professor Hessig, who knows a lot about criminal law and criminal procedure. The criminal procedure rights didn't really get life breathed into them until the 1950s and 1960s. So the Second Amendment wasn't too far behind in that respect. Another partial explanation is just that the Supreme Court and the justices just don't care as much about guns as they do about other things. And I think there's probably something to that, right? Lots of Supreme Court outcomes can be justified or described, at least explained, in terms of the things that the justices care about. And that's true whether it's guns, whether it's voting rights, whether it's abortion, whether it's the powers of the president. And it may be the case that the justices, like all judges and lawyers who sort of live in a world of words, care more about the First Amendment and the Free Speech Clause than they do about the Second Amendment. Maybe it's just not, it doesn't have as much attention paid to it. I think there's probably something partially right about that. But the other explanation, I think, is that the justices were just happy with the interpretation that they and the lower courts had given to the Second Amendment. So the Miller case, which Professor Kotzen mentioned, it's not a long case. It was a case only argued in one side. The other lawyer didn't show up. Not one of the Supreme Court's like best pieces of work, but it does, I think, articulate a vision of what the Second Amendment's all about, which is the protection of the organized militia from disarmament. The Miller case, just to give you the basic facts here, involved a guy named Jack Miller, who was a bank robber caught with a sawed-off shotgun, which as of the 1930s were illegal under federal law. He argued, I have a Second Amendment right to have this shotgun, this sawed-off shotgun. Took his case all the way up to the Supreme Court, and the justices said, well, we can't take any judicial notice of the notion that a shotgun, a sawed-off shotgun, has any connection to the militia, therefore you don't have any right to possess it. Basically, what that's saying is the only laws that are going to raise Second Amendment challenges are those that have to do with disarming the organized militia. Most laws don't do that, so they're not going to kick up any cases. Now, we'll talk later about how the Supreme Court sort of changes its view there, but I think one way to look at it is just there was an interpretation. It was about the organized militia. That doesn't generate a lot of cases. In the same way, I'll say this sort of in closing, talking about the First Amendment here, lots and lots of First Amendment cases, especially starting in the 19-teens and 1920s. So you might say, well, why is the Second Amendment so quiet when its neighbor over here is getting all this attention? Well, think about its neighbor on the other side, the Third Amendment. Right? Does anybody know? I see the law professors are laughing. Does anybody know what the Third Amendment does? Prevents quartering of troops in your home during peacetime. Literally 0 Supreme Court cases about the Third Amendment, right? Which in some ways means it's the only one that works. It never gets violated, right? And one way to understand the Second Amendment and the Supreme Court's silence is that it was working according to the way the Supreme Court was interpreting it. At least that's some partial theories.
Amy?
Yeah. So I think Joseph and I, at some point later on tonight, we will disagree about the facts of Miller and how to interpret the Miller case that he talks about. But I think it is true, undeniably, that regardless of how we might disagree, it was used by the courts throughout the next almost 100 years, right, to sort of summarily dismiss all Second Amendment claims. And I largely agree with aspects of the 3 points he brings up, but I'll raise a couple others. I think one reason the Supreme Court has been so slow to jump in on Second Amendment issues also has to deal with the practical reality of the growth and development of what we would consider like modern conceptions of gun control, especially at the federal level. Most of the most contentious types of and most restrictive types of gun control that we argue about today, things like assault weapons bans, et cetera, those don't really start popping up until much later on. So you look at the scope of federal gun control in Miller, for example. Miller is dealing with the National Firearms Act, which was, compared to modern gun control, fairly limited. It dealt with very specific types of firearms that I think we generally agree were not commonly implicated for ordinary law-abiding citizens, which is why that legislation was fairly not controversial. And it was really under a taxing scheme. Yes, it was a prohibitive tax. $200 at the time is the equivalent of several thousand today. But that was about it, right? It's not really until the 1960s you get the Gun Control Act, where for the first time you start seeing sort of major limitations, and even that's pretty limited. It's really, you start seeing this come up within the last maybe 30, 40 years, these broader schemes. And now, yes, obviously, the court could have weighed in on those. I think even the federal assault weapons ban that was implemented for 10 years, the court never weighs in on that. And to the extent it does, right, we're not arguing today like we are under our current framework. Federal circuit courts would largely just dismiss these as, well, of course, you don't have a right to this under Miller, and we're bound by the Supreme Court precedent in Miller, and that's just sort of how they would read it. So I think there's a practical aspect to that as well. In terms of what we're seeing today, and just to build off some of the things that Joseph said, I think it feels like we're watching a court that doesn't want to weigh in on this issue. I know certainly it's frustrating sometimes for those of us who are, we'd consider ourselves Second Amendment advocates, right? Or even just legal scholars in this field. We're like, give us answers, right? But this is a unique situation in American law where we are watching real time the building up of a framework, of a jurisprudential framework from scratch, and we're not used to this, right? We otherwise have existed in a context where we go to law school, we go to college, we start practicing, and we've already had these First Amendment, Fourth Amendment, Fifth Amendment frameworks inherited, right, ready to go. But as Joseph said, those took time. We just have never had to experience that building up in real time. And so there is, I think, some frustration and really just a perception problem and an impatience that we're not used to that plays into that. And I think that plays into a lot of people's inclination to jump on this, immediate bandwagon of, well, they're not jumping into these cases for political reasons, or they're not jumping into these cases because they just don't care about it. I think it's pretty par for the course historically, even though it is frustrating from our perception of having to deal with it in real time.
So I think it's a nice segue into what the current jurisprudential framework looks like, which really started to develop in pretty quick succession in 2008 and 2010 when we got these major blockbuster Second Amendment cases out of the Supreme Court. In 2008, we had District of Columbia versus Heller, and in 2010, McDonald versus City of Chicago. Joseph, can you give us a broad overview of what those cases tell us and what framework they
I'll try to do it
establish?
broad and quick. There's lots and lots one can say about these cases, and I want to start just by underlining a point of like deep agreement that Amy and I have here, which is just one of the things that's so fascinating and important about this area of constitutional law is that we are seeing doctrinal frameworks develop in front of us, which we're just not used to. Like the fact that, this goes back to your first question, Matt, the fact that all this stuff is so recent, I'm about to tell you when the Second Amendment was essentially born, is not something we're familiar with in other areas of constitutional law, makes it, I think, especially challenging and important. So the sort of date of birth, if you want to, for the modern Second Amendment is 2008, with the Supreme Court's decision in District of Columbia versus Heller. And sort of simplified a little bit, the question in Heller essentially was, what does the Second Amendment right protect? Like, what is the core interest that it's all about? And again, oversimplifying, there's sort of two different visions here. One, to go back to the sort of prefatory versus operative clause distinction, focuses on that first part, the well-regulated militia being necessary to the security of a free state, and says that the point of this amendment was to protect the organized militia, like the state militia, major institutions in 1791, from disarmament potentially by the federal government, right? Which sounds anachronistic to us today, but recall that in 1789, when the Constitution was ratified, this whole system of a federal government, let alone a federal standing army, was thought to be terrifying by many. So the thought was, we'll protect the states from disarmament, that's a check on federal tyranny. That's the militia-based view. That's the one that I think was endorsed in Miller, although Amy and I might disagree about that. The second vision, though, is what I'll call the individual rights reading, the private purposes reading, which tends to focus on the second clause, the one that Matt called operative, which is, the right to keep and bear arms, the right of people to keep and bear arms should not be infringed. And the argument here is the right is at least not limited to the militia or the organized militia. It includes the general militia, all people who might be called to serve, and it encompasses things like a right to use or have arms, at least for purposes like self-defense that don't have to do with militia service, right? So the question, the central question in Heller is, which of these two visions of the amendment is correct? And in a 5-4 decision authored by Justice Scalia, the court endorses the private purposes view and rejects the militia-based view. So that, and sort of just like one sentence takeaway from Heller, that's the big thing. Because once you have a Second Amendment right that encompasses the right to use guns or have guns, at least for self-defense, now you really have a right that can generate cases, right, that actually people will maybe invoke. If you guys know anything about Justice Scalia, you won't be surprised to hear that this is an originalist opinion. It's one that draws a lot on history, much more than it draws on cases and statutes and constitutional provisions. It actually cites more secondary sources and cites them more often than all traditional legal materials combined. But the division on the court is not between the originalists and the non-originalists, or at least originalism and non-originalism, because the lead dissent by Justice John Paul Stevens also takes an originalist frame, looks at some of the same historical records actually, and comes to the opposite conclusion and says, no, the militia interpretation was right. So that's the big takeaway from Heller. I would say the other part, and this part that people often gets overlooked in Heller, is that having endorsed the individual rights view is not the end of the case. Because, as Justice Scalia rightly recognizes, all constitutional rights are subject to various forms of regulation, right? Like your right to free speech, to go back to that one, does not include your right to libel or slander or commit securities fraud or perjury, right? Those are all things that can be regulated. Even political speech can be regulated in certain contexts. Heller doesn't tell us a whole lot about what kinds of regulations are or are not constitutional or why, but it does give some examples. The court says nothing in our opinion should be taken to cast doubt on such long-standing prohibitions as those relating to felons, the mentally ill, dangerous and unusual weapons, sensitive places such as schools and government buildings. Doesn't really say a lot about why those are okay, sort of leaves that to the lower courts to figure out. But that second part, I think, is really important because it puts Heller in context. This is a case that like most Americans already believe, recognizes an individual right to keep and bear arms. 75% of Americans agreed with that. Both political parties endorsed that view. And also that some forms of regulation are permissible, right? So just one sentence or two sentences on the McDonald case. For the lawyers in the room will know this, that the Bill of Rights technically, in the first instance, only applies to the federal government. So Heller, District of Columbia versus Heller, federal case, District of Columbia is the federal government. Leaves open the question, well, what about states and local governments? What about North Carolina passing a gun law, or New York, or California? In McDonald, the court applied the doctrine of what's called incorporation and made that federal constitution, that constitutional right that applied to the federal government apply also to states and local governments. The reason that's really important is that a whole lot of gun regulation happens at the state level, less so at the local level, but some at the state level. So a lot of the cases that we'll end up talking about come from the states. That's a snapshot of Heller and McDonald.
Thanks. Amy, do you have anything to add?
Yeah, so I would frame it, I would frame 2008 and Heller not as sort of the birth of the modern Second Amendment or the idea of the amendment as encompassing an individual right. I would say it's more of its legal resuscitation. So as Joseph sort of hinted at, most Americans, for at least the last several decades that we've been taking polls on this, the presumption has been, yes, there's an individual right, even though within the legal sort of field of this, you've had courts upholding laws up until 2008, basically saying, no, there's not, based on this 1930s case of Miller. So I would call it its resuscitation, because when I would look at sort of the general history of the United States, including sort of discussions of the right throughout history, I think it's pretty clear, at least in my view, that you see there's always been an understanding from the very beginning that this was an individual right, yes, that is connected to the militia in the sense of there was this presumption that we've sort of lost today and feels foreign to us, to imagine that your individual right would have a corresponding duty attached to it, that it was presumed the average person was armed and that they could then be called upon in this time when we feared large standing armies, right, when the natural defense was the calling up of the citizen soldier, and sort of just like you were expected to show up to jury duty, right, you were expected to show up to militia service and to be ready to be called upon. I think that's always been there with that individual right attached to it, even if we really don't see that cemented within the legal setting until 2008. So I would push back a little bit on that, and I think you see that even in the Miller case. So Miller was about what types of weapons are protected, and it really is, not only is it a weird case, and Joseph sort of hinted at this, it's a weird case when you read the background facts of it. I think Miller's actually dead by the time the case comes out, or at least by the time the opinion comes out. The way that the court words its opinion is confusing. So it does talk about this connection to militia service and whether or not that type of weapon has a bearing within a militia context, but it also uses language and cites to sources that, again, sort of presume, well, these were weapons that people individually had that would then be useful for calling up within the militia. And as we, assuming we get into types of weapons that are protected under Heller and McDonald, it also uses what we would incorporate today as this modern language of common use and common possession. So even Miller is confusing insofar as it's not really clear, at least in my opinion, that it foreclosed that individual rights there, even if that's how it's interpreted. So that, again, Joseph and I know this, we disagree on it, but my pushback.
So let me follow up on that a bit. So one thing I've always been kind of confused about by Justice Scalia's opinion in Heller, you mentioned the kind of two interpretations, the individual rights and the militia interpretation. It seems like there are at least three different readings on the table here. So one is the view that I think Justice Stevens articulates in dissent, right, which is, look, the prefatory clause highly restricts the operative clause. In order for a weapon to be protected under the Second Amendment, it has to be directly related to actual militia use and actual militia purpose. On the other end of the spectrum is the view that the prefatory clause doesn't restrict the operative clause at all. It's just announcing a purpose. It's like throat clearing. It's like this is why the operative clause exists, but it just does nothing at all. And there are times at which Justice Scalia seems to be articulating that kind of view. He says a prefatory clause announces a purpose, but suggests that it doesn't do anything else. Then there's a view that's kind of in the middle, which is to say, no, the prefatory clause does restrict the operative clause, but it restricts the type of weapon, not the purpose to which that weapon is used. So in order for a weapon to be protected by the Second Amendment on this kind of middle reading, it has to be a weapon that's suitable for use, for a militia use, suitable for use in a militia. But that doesn't mean that it's only protected when it's being used in an actual militia. Once you have a militia-suitable weapon, you can use it for hunting or for self-defense or whatever. And there are times, especially when Justice Scalia is discussing the Miller opinion and trying to articulate the view that the holding in Heller is perfectly compatible with Miller, where he seems to lean more into that second view. I've never been able to quite identify which of those latter two views Justice Scalia actually holds. Am I right to be confused here, or is the answer clear?
The answer's not clear to me. I mean, I think it's a central challenge, and I'm sure we'll talk about this more, and Amy sort of flagged this, like what kinds of weapons, and likewise, what kinds of people and what kinds of places are encompassed by the Second Amendment may be informed by the sort of purpose, like what's the underlying reason why the amendment exists, whether it's militia or self-defense or some combination or even something else entirely, right? And that might come back to your vision about, is the Second Amendment about the prevention of tyranny, or is it about self-defense as against criminals, right? Those lead to very different places, to come back to your question, Matt, about what kinds of weapons are covered by the Second Amendment, right? So Heller and the court's later cases have some language that suggests self-defense is the core of the right, but some of it seems to embrace more of an anti-tyranny view, which some people share. That's a hard thing to square with the exceptions that the court names, right? Like, if your vision of the Second Amendment is sort of, well, the weapons that are covered are those that are suitable for military purposes, well, that's hard to square with the notion that dangerous and unusual weapons can be prohibited, because, of course, the weapons that one might need for military service, let alone to overthrow a tyrannical government, are probably going to be things like flamethrowers and machine guns, which are heavily regulated or prohibited under federal law now. And that doesn't seem right. And where are you going to need to take those guns? To sensitive places like government buildings and schools. And, of course, those are subject to prohibition as well. If you say it's about self-defense, well, then how can it be that felons and the mentally ill don't get to exercise the right? Because after all, they have rights to self-defense, maybe heightened need for it, right? So to map the sort of carve-outs onto the underlying reasons, I think, is like an ongoing challenge, certainly something the court still has to revisit. I don't have a clear answer to what was in Justice Scalia's head, but it strikes me as a continuing problem.
Thanks. So the next substantial case that the court decided on the Second Amendment was Caetano versus Massachusetts, which involved this Massachusetts law forbidding the possession of stun guns, electrical stun guns. And so stun guns obviously didn't exist at the time of the founding, but Heller, I think it had been reasonably clear in Heller that the Second Amendment right extended also not just to weapons that actually existed at the time of the founding, but even so the mere fact that electrical stun guns didn't exist at the time of the founding was not an impediment to its Second Amendment protection. And so then we got into this question which Joseph just alluded to about dangerous and unusual weapons. And I want to ask about unusual. So it's pretty clear that from reading Heller that unusual does not mean unusual at the time of the founding. Unusual means something more like unusual in the current political, economic, social climate in which the case is being determined. Now, I don't know how unusual stun guns are, presumably not that unusual, but we can imagine weapons which are more unusual than that, maybe even non-existent, deatomizing ray guns that can kill thousands of people and so forth. Those are presumably pretty close to non-existent now. One odd thing, though, about dangerous and unusual weapons is that as long as the weapon is unusual, it can be prohibited. But then if it gets more usual, perhaps because people illegally possess it, distribute it, then it's not unusual anymore, and so the Second Amendment starts to protect it. Does that create a kind of weird dynamic or a weird incentive structure where weapons are protected by the Second Amendment when they're usual, not when they're unusual, but it seems like things can easily become usual.
And part of the reason this is convoluted, and Joseph sort of flagged this, right, is that the court, this is one of the aspects of the Second Amendment sort of framework that the court really needs to dive into. because it's only sort of given us bits and pieces in with respect to handguns. And insofar as it has tangentially addressed this question in certain cases, even dating back to Miller, it has used various types of language, right? Is it dangerous and unusual? Is it common possession? In Heller, it talks about being commonly possessed by law-abiding citizens for lawful purposes. How much does it relate back to individual self-defense versus this tie-in to this collective duty, right? This corresponding duty and tie into militia service and usefulness in the militia, as Scalia sort of recognizes this tension in his infamous M16 dialogue. And I think part of the problem is we've used different language for it. And now we have the Bruin test where it's history and tradition, and it's like, does that subsume these tests? Are they all different tests? What do we do with this? But also just the technological reality of how firearms have developed has complicated this. So at the time of the founding, there was a 1-to-1 ratio to answer this question, right? Bearable small arms that people just possessed because they existed, 1-to-1 ratio of the exact types of weapons that you would roll up to for malicious service, right? And then you could make a textual distinction, you know, is it arms or is it ordnance, right? The thing that shoots and then explodes, right? You could draw that parallel, but there wasn't really this gray area. And as firearms have developed, as you start getting into not just fully automatic weapons, for example, but things like crew-served weapons, surface-to-air missiles, flamethrowers, right? Now we sort of have this broader category of weapons where, even things like stun guns, right? Where you have this broader spectrum of weapons that, some of which are still very much intrinsically useful for self-defense, and some of which are more intrinsically related to active warfare, right? And many of which sort of fall in between, or like stun guns sort of fall over here. It's like you probably are not going to show up to militia duty with a stun gun, right? And if we do, we're in trouble at that point. So I think that sort of exacerbates it as well, just the reality of technology in a way that exists in the court has not resolved that. And I think you will see, this is part of the reason they haven't taken up some of these cases. I suspect there is profound disagreement, even amongst the justices who would agree about Heller and McDonald, about how do we, going forward, resolve this in the most practical way.
Thanks.
If I just add a few quick thoughts on that. I mean, I agree with a lot of what Amy said there. I mean, I think you're going to hear us say the court needs to do this, needs to do that, needs to clarify, and it sounds like we're critiquing the doctrine, and to some degree we are. I also want to recognize these are hard questions. I mean, the court still struggles with what kinds of things count as speech under the First Amendment. It's not easy to answer what counts as an arm under the Second Amendment. And I think the common use test or the dangerous and unusual test is a clumsy tool, but I say that without having been able to articulate necessarily a better one myself. I think your point, Matt, about perverse incentives is exactly right, and it sets perverse incentives in at least two directions. If the test for whether something is constitutionally protected under the Second Amendment as an arm is whether it's in common use, well, that sets perverse incentives for the government to regulate all new weapons before they become common, therefore maybe under-protecting the Second Amendment, and it sets perverse incentives for the gun industry to flood the market with new things such that they can now claim, you know, high-capacity magazine, however you define that, is now in common use because, look, there's however many hundreds of millions of them in circulation. Neither of those things seems to me to track what we actually care about, given that the right is one to have a gun on hand, at least for armed self-defense, which is, does the prohibition of this thing impact people's ability to defend themselves? And that's a hard question, but it's not one that's answered, at least directly, by whether the particular weapon in question is in common use. I'd say, too, it's actually really hard to decide, well, what counts as common and what counts as use? See, in some of these cases, we've mentioned a few of the assault weapons cases, we've seen some of these cases judges saying, well, you know, among those who own what are often called assault weapons, basically just semi-automatic rifles with certain cosmetic features, of those who own those weapons, the primary reason for owning them is self-defense, therefore they're in common use for self-defense. That's one way to look at it. Another one is, well, how often are they actually used, like trigger pulled or brandished in self-defense, in which case the number is quite low. I mean, the Constitution doesn't answer those two, which of those is right, but they point in very different directions with regard to the constitutionality of gun laws. And I guess the last thing I'll say here, this is coming back to something Amy mentioned earlier about how the regulatory environment has become a lot thicker with regard to guns. And I agree, of course, that things like the assault weapons ban are relatively recent inventions, but part of the explanation for that is exactly what Amy just described. The technology's changed, right? The semi-automatic weapon itself, that is one that fires a bullet with each pull of the trigger and then reloads itself, even that wasn't really in common use by any measure until 100 years ago. That's the standard form of weaponry now. There, of course, aren't going to be assault weapons bans in the 1800s because Eugene Stoner hadn't yet invented the assault weapon. And so one of the hardest things is the law trying to keep up with the technology while also staying rooted in these sort of historical principles. It's a very hard dance.
Thanks. So, Amy, you mentioned the development of the framework in Bruin in 2022 and Rahimi in 2024. Can you give us an overview of how the framework evolved or changed or was supplanted by 2022 and 24 in Rahimi and Bruin?
Yeah, so, circle back for a minute to Heller and McDonald, right? So the court tells us there's an individual right to keep and bear arms. It's rooted at its core in self-defense, and it's applicable against the states of the 14th Amendment. Something, text, history, and tradition are important, but it never really tells us what the test is. And then it doesn't talk about it for 12 years. And so what happens in the interim is in the lower courts, nothing changes. The lower courts come up with what's called the two-step test. We don't have to get into the specifics of it. At the end of the day, the second step of this test would be used under what's known as some sort of heightened type of scrutiny in such a way that basically nothing changed. There were circuit courts that never had to find a gun control law that wasn't perfectly constitutional under Heller. And so the status quo sort of stayed the same. That brings us to 2022 and Bruin. So Bruin dealt with a challenge to New York's what was known as good cause, proper cause requirement for concealed carry. Right? So very specifically, it was a question about, does the Second Amendment apply at all outside the home? Do you have a right to carry outside the home? Because the way that New York's law worked in practice was that you did not have good and proper cause. If you were just an ordinary law-abiding citizen, you were never going to get a concealed carry permit. And New York basically argues this is fine because you don't have a right to bear arms in public or outside the home. And even if you do, well, this is a reasonable way of us dealing with public safety concerns. And the court does two things. So first, it strikes down that good cause requirement, this sort of de facto prohibition on public carry. It says, yes, there is a right to bear arms outside the home. We're not going to get into the specifics of all of we're not striking down every regulation that can possibly exist. In fact, it goes to pretty great lengths to sort of reassure a lot of that a lot of other state laws that were not this restrictive were not being called into question here. But it does strike down New York's law insofar as it basically requires a showing, a demonstration that could not be met by ordinary citizens. And then, perhaps just as importantly, it finally tells us what the test is. It is not this tiers of scrutiny or this two-step test that it adopts, but it is one that goes back to this idea of text, history, and tradition. And it is essentially this, that when the person who is arguing against these laws, who wants these laws struck down, when they can show that their conduct is covered by the Second Amendment, at least on its face, then the government has to justify its regulation by showing that it is consistent with some national historical tradition of firearms regulation. Now, what does this mean? Well, the court points to two central metrics, right? So it says you have to look at this history of firearms regulation and show that your modern law is consistent insofar as it does the same thing, the same type of restriction for the same type of reasons. Okay? You don't have to have a dead ringer for the historical law, but it needs to be relatively close, right? And it's sort of vague as applied to anything else because it's only done this now in 2 cases. But at least insofar as it applies it to New York's law, it says, look, historically, we have a tradition of, regulating public carry to some extent. We regulate the intent for which a person can carry. We've long done that. This idea of you can't go around armed to the terror of the public. We've regulated the manner in which people can carry. Historically, there were stricter regulations on concealed carry, but it was because the gentleman's way of carrying was open carry, which New York said you couldn't do. And then we've also had this sort of limited conception of there are some very specific sensitive places in which you can't carry. But generally speaking, we haven't otherwise had this historic tradition of just broadly saying the only people who can carry in public are those who demonstrate some special need. And that was really all the court gave us, which isn't a whole lot to go off of, but again, this is one case and it takes time. And then you get to Rahimi. Rahimi, another just fascinating set of facts in that case. Mr. Rahimi, if you're not familiar with this case, he's a bad guy. Just everybody agrees he should not no one should give him his guns back. So this deals with a federal statute that makes it a crime that prohibits individuals from keeping and bearing arms if they are subject to certain types of domestic violence restraining orders. Mr. Rahimi was subject to one such restraining order. He then goes on to ignore that restraining order, gets into a whole lot of shootings. The real miracle of this is that he has the aim of an Imperial stormtrooper and, thank God, injures no one. He's arrested for this. He's charged with a bunch of state offenses. I think he's currently in prison. He's going to be in prison for a long time. But then along with this, the federal government says, oh, we're going to charge you under federal law for violating the statute. And he, after Bruin, says, well, we don't have a historical tradition of punishing people for violating restraining orders that say you can't keep and bear arms. It's a Second Amendment violation. This is not the way historically we've disarmed people. Now, I want to be very clear. No one was arguing that Mr. Rahimi had a right to keep and bear arms as a dangerous person. It was a matter of how constitutionally can we disarm him, and he was arguing not this way, and then you put me in prison for violating it this way. And the Supreme Court ultimately upholds this statute under a facial challenge. And it, again, uses this text history and tradition, this recognition of comparing this to this historical tradition of firearms regulation. And it says, look, this is remotely similar to how we've done this in the past. That you don't need this historical twin of, yes, in 1792 we had domestic violence restraining orders, but there is a historical tradition of using these types of civil processes as a means by which to disarm people who are specifically dangerous. And now there are limitations on this, right? You can't do this in perpetuity, that it would seem to be connected to some sort of time limitation there. But it sort of draws a broader conception than I think a lot of Second Amendment advocates were hoping for after Bruin. I think there was some hope that what the court would say is almost essentially if there's not a dead ringer, you can't do it. But the court, once again, sort of adopts this, I don't know, broader, more moderate ground, where it's still, I think, at the end of this, not very clear where the edges are. And we're not going to learn those edges until the court continues taking up more of these cases and sort of demonstrating how this works in practice.
So, I guess one other point of ambiguity here is sensitive places. How broadly, how narrowly is a sensitive place to be defined? I mean, is the island of Manhattan a sensitive place? Is the Research Triangle a sensitive place? So,
New York says yes, by the way.
Yeah.
right. So, has either the Supreme Court or lower courts given us any guidance about how to think about these?
To the first question, yes.
Okay.
The island of Manhattan as a whole cannot be designated a sensitive place in which guns can be prohibited. But the reason that it's actually and I agree with Amy here, that New York does argue something like that. The reason it's hard, or I think at least a little bit hard, is that the court has said government buildings and schools are places where guns can be prohibited. And if you live in a densely populated area where those things are all close to each other, and let's say you can also ban guns 50 feet outside of those things, then you do end up with a patchwork where a whole lot of an area might be marked off as sensitive. Add in hospitals and other places that are often regarded as sensitive. Then the question becomes, well, what gives? The sensitive places or a person's desire or right to carry a gun across the city? It's a tough kind of legal remedy question. I mean, I think for me anyway, and I agree with Amy's description of Bruin and Rahimi exactly, including the point that Rahimi gives a little bit of a sort of like, as I would say, sort of like loosens a little bit the historical test that Bruin articulates. Bruin says, in order to be constitutional, a modern gun law has to be consistent with our history of firearms regulation. Rahimi says, sort of same thing, but has to be consistent with the principles that underpin our historical tradition of firearms regulation. I think it's like a little bit of a higher level of generality. But in both instances, and I think people on all sides of the cases are saying history matters. It's just a question of like how much can it actually answer. So in the questions of hospitals, for example, there's actually a case that arose here at UNC. The question may be posed, can guns be prohibited in hospitals, right? So you're a judge, you're trying to apply Bruin and Rahimi, so you say, well, what was the historical tradition of regulating guns in hospitals in 1791? You look back to 1791, and what did you find? They don't have hospitals, right? There's just the institution of a hospital doesn't exist in the way that we recognize it today. So you say, okay, I got to go to a higher level of generality to find something that's going to give me some guidance here, just like you might do with dangerous persons, right? And at a certain point, I think like the legal question becomes totally unmoored from like the actual questions before courts. And just another example on sensitive places, since you asked about it, many places prohibit guns on places of public transit, right? Like the DC Metro, the subway in New York, public transit in Chicago. Those have all been challenged as violating the Second Amendment, right? Judges trying to resolve those cases have to ask, well, what is the historical tradition or the principles underlying the historical tradition of regulating guns in places of public transit, right? Again, you'll get no coherent answers, even any coherent guidance from 1791, because there was no mass transit. They didn't even have omnibuses until later, let alone railroads. And so I think what I see, at least in the sensitive places cases, in the class of arms cases, even in the cases involving dangerous persons like Rahimi, is courts really struggling to just get guidance out of a historical record, which frankly both overprotected, depending on how you read it, and underprotected constitutional rights, including the Second Amendment. Like, in the time of the founding, were there broad gun laws? And maybe Amy and I would disagree about this, but I don't think so. Were there broad gun laws that disarmed people? I think absolutely so. It's just that they were terrible laws that nobody would want to learn from today. I mean, the laws that disarmed people back then, who was targeted? Who would you think? Native Americans, Black Americans, Catholics, Loyalists. Those are very stringent gun laws, clearly unconstitutional today. What guidance do we want to draw from those, especially given that at the time, as Amy sort of suggested, we weren't protecting people, especially women, from intimate partner violence involving guns. To me, it's just, the Bruin test has introduced a whole lot of, in my view, confusion and certainly, unarguably, disagreement in the lower courts.
So some of this point about sensitive places, especially when areas where based on geography, based on demographics, sensitive places are right on top of each other, public transit being very different from different parts of the country where that isn't the case. I think that connects with some of your work defending a kind of firearm localism, I think you call it, where there is a long history in America of regulating guns very differently in cities than in rural areas, and where you've suggested that Second Amendment doctrine can and should incorporate those differences. Am I getting that roughly right?
Yeah, roughly right. I mean, this is something I should say. It was written long before Bruin. This is an article I was writing back in 2013, I guess. And the basic insight, I think, is something that most people share, which is that there shouldn't be a one-size-fits-all, geographically, approach to gun regulation. Right? Gun problems and gun benefits just look very different in different parts of the country. And I think it's a hard ask to tell people in Montana, you can't use AR-15s to shoot varmints because people in Manhattan are shooting each other with those guns. But likewise, it's hard to tell people in Manhattan, you can't regulate these guns here where they're being used to kill people, because out in other areas of the country where they're being used for hunting, we want to protect that. I mean, sometimes you can actually separate these issues and regulate differently in different areas. So just it's just sort of like common sense to me. And maybe this is just like I grew up in Durham. My family's from Davidson County, more rural county. My experience of growing up with guns, very different in Durham than when I was visiting my grandparents out in Davidson County. I'm like, that seems fine to me. That makes total sense. It also happens to be consistent with historically how we've regulated guns in this country, which is that there has always been a deep division between urban and rural areas with the approaches they take to guns. That goes all the way back to the founding. Philadelphia, New York, Boston, like the big towns in the colonial era, had really stringent regulations about gunpowder regulation, where you could fire guns. It wasn't just an East Coast thing. When the country expands and goes west, look at the towns you might most associate with guns, places like Dodge City, Tombstone, Arizona, prohibited from carrying your gun in the town. You had to check it when you got to the city limits. You could carry it in between, where you might be defending yourself against all kinds of threats, but in the city, different rules applied, right? And the same sort of consistent thread goes throughout American history until the 1980s, 1990s, when states started clamping down on local government's ability to pass those kinds of laws. So my argument was essentially just at the margins, it matters whether the law being challenged regulates a city versus not. Now, two caveats, just to be clear here. Never argue, don't believe that cities or any other area should be exempt from the Second Amendment, nor do I think that local regulations are a solution to all problems, right? Like New York's gun violence problem, New York City's gun violence problem. New York actually as a state has one of the lowest rates of gun death in the whole country. But New York City, to the degree that it has a problem with gun violence, it's not guns being bought in New York. They're guns that are traveling up from places like North Carolina, ditto Chicago. So local regulations aren't going to be able to stop that flow. But regulations on like open carry, for example, I think it makes sense to do those at the local level. It sends a very different message if you're open carrying an AR-15 down Madison Avenue than if you're doing it in Montana during hunting season, or if you're doing it around here during deer season. And so the argument essentially was just for more local variation, just like lower the temperature so that more people can be satisfied by the laws.
And Amy, turning to some of the ways in which these tests and these constitutional constraints interact with policy initiatives by legislatures, either at the state or federal level, and by presidential administrations. You've been critical in print of the Biden administration's efforts to, you said, weaponize the Bureau of Alcohol, Tobacco, Firearms, and Explosives against peaceable gun owners. Could you explain to us a little bit about what your criticisms of the Biden administration's approach to gun control have been, and contrast that for us with both the first and second Trump administration, insofar as we have a sense of the latter?
So first, I'm going to take 20 seconds
Of course.
to go back to our last point about firearms localism. What's interesting to me on this is that Joe Spinner are actually not that far off on this. I think most people would agree that historically, just the way that the police power works, right, it has been the states and localities that have imposed or declined to impose various types of firearms regulations. And I think this is, to an extent, good and helpful and right in just sort of how the police power and federalism works. And I'm not that I suspected you did not agree that, you know, there's not limits to where Hawaii can't say, well, the Second Amendment doesn't apply here because of the spirit of aloha. If you don't know that reference, we will talk later. They tried that argument. I think what we would disagree on most fundamentally is sort of where that limit between what the Second Amendment compels as sort of a bare floor is, and where that localism starts getting into, you know, that gray area of overregulation. And I think that gets lost on a lot of people, that most times people are a lot closer on this issue than we'd like to believe. In terms of your actual question. Yeah, so like, this is a great question because I make no one happy with my answer. If you were hoping that my answer would be the ATF is an agency that was conceived in constitutional sin and came out of like the executive branch room just covered in iniquity, the answer is no. It's a weird agency. It's got a weird history. But at its best, it is a very, very useful and powerful tool to protect Americans from violent crime when it is focused on its goal. Now, it has a tendency to have its fairly broad powers wielded in arbitrary and abusive ways. We saw this a little bit in the late 70s and early 80s. But I think we really saw it unfortunately, under the Biden administration, and I would call it the weaponization of ATF in several ways. So I think fundamentally it stems from this effort to do via the executive rule, the agency rulemaking process, that which the administration could not accomplish by getting Congress to pass it through law. So you look at things like the rule sort of reinterpreting who is subject to background checks. Who federal law would consider is engaged in the business such that they, must go through background checks when they're selling. They tried to get really as close to universal background checks as they could without just saying, well, the law doesn't say universal background checks, but universal background checks. Things where it was like you were presumed to be engaged in the business if you displayed your items at a gun show regardless, right? If you were advertising online. Just complete departures from sort of the historical way ATF has understood that phrase. When you look at other rules that were passed, things like the pistol brace rule, right? That was aimed at several millions of otherwise ordinary law-abiding citizens who ATF for 10 years had said, no, those are not short-barrel rifles, right? All of a sudden, there was this about face to largely target the law-abiding ordinary citizens who were going to be the only people complying with this law and either getting rid of these firearms or registering them under the National Firearms Act. It was not going to be your people who owned them illegally, who are going to narc on themselves, like, yeah, we have these firearms. It was just unnecessary. Things like the zero tolerance policy rule against FFLs, where overnight the agency broke its trust in sort of this decades of relationship building it had done with the lawful gun industry to work as its partner and sort of became an antagonist in a way that I think was not only unnecessary but unhelpful to its own goals, where it sort of lost sight of what its goal was, and in so doing undermined its ability to actually do the things and spend the resources in ways that keep us safer. Now, to pivot to the Trump administration, number one, largely didn't do a whole lot. And I think most people recognize that. Sort of left ATF unattended, which I think for a long time was the Republican and sort of Second Amendment activist goal, right? Just don't put a head of ATF and then it can't do anything. The second time, I think you're seeing a more active approach immediately, not just to sort of undo some of the Biden administration's regulatory rules, but to actively wield ATF in a way that is helpful for gun owners, to clarify some of these aspects of federal law, and to work on behalf of lawful ordinary gun owners in a proactive way. I'll give you just one example. So if you're familiar with federal firearms disability, so people who are prohibited persons because they've been convicted under federal law of any, Martha Stewart, who under federal law is a prohibited person. We've had for several decades now a mechanism to restore those rights, like most states have, but it was given to ATF, and then Congress said we're not going to fund it. And so basically there was no way for anybody to ever get their firearms rights back. And one of the steps that you're seeing, and that I think hopefully the administration is serious about, is removing that power from ATF, giving it to DOJ, so that it's no longer subject to, well, we didn't fund it, and actually giving people a mechanism to stop being punished decades after their offense. Now, clearly not to give it back to people who are still violent offenders, who are risks of violence. I think we'd all agree on that. But to have some end, some mechanism of restoration, I think that's good and that's appropriate. And you get weird bedfellows on that question as well, which just makes it doubly fun. But I don't think this second administration, I think there are some I don't want to call them red flags, but for example, the ghost gun kit rule that the Supreme Court just upheld, the administration did not intervene in that. It could have, it chose not to. So I think to the extent that it continues working on behalf of gun owners, ordinary law-abiding gun owners, won't be as extreme as people either hope or fear, depending on where you fall on that. But I think it will be the most active administration efforts that potentially we've ever seen.
Joseph, thoughts?
No, I mean, I agree with a lot of that. I mean, descriptively, and Amy, I may disagree about like, which of those moves are desirable or not. You guys may have seen a lot of the reporting this week was about the termination of the zero tolerance policy, as it was called, which I think was Monday they decided that they're not going to do anymore.
Time is a square circle.
Yeah, so these days it's hard to keep up. I was probably more fan of that than Amy. I mean, as I understood it, and you can correct me on this, the policy was for federally licensed dealers found to have willfully violated federal law, for example, by not doing background checks as they're required to, or that they would lose their licenses. And that to me, like, maybe that was being misapplied in practice. I just point to it as like an example of like a way in which you can think about gun law as more than just scooping up people off the street who are in possession of guns, and try to think about sort of like upstream, if you like, sort of solutions. And again, we may agree or not on whether they're good, but I think a lot of the attention in the debate right now is going to be above and beyond what we're talking about, which is the Second Amendment and its restriction on government, and has a lot to do with things like lawsuits against the gun industry, like tort lawsuits, which are not directly constitutional questions, at least not yet, but will raise a lot of interesting ones. And I want to underline a point of, since we may disagree about zero tolerance, I emphatically agree with the importance of the restoration. This is something that, like, it's actually embarrassing, I think, that parties have not focused on more. I think the breadth of the problem is huge, that the people who are disarmed under federal law, many of them have absolutely no reason to not have access to guns if they want them still, right? The federal law, 18 U.S.C. 922 G1, which prohibits people who've been convicted of a crime punishable by more than a year from possessing guns, sweeps in all kinds of people, like Martha Stewart, like the Third Circuit case, which Amy and I know very well, a guy who 2 decades ago committed a minor welfare fraud, essentially to get food stamps, right? Happens to be punishable by more than a year. He's now lifetime barred from having guns. It's a ridiculous outcome. There has to be ways for people like that to get their gun rights back. I would say the same under the same 18 U.S.C. 922G also prohibits people who've been at any time in their life involuntarily committed for mental illness or mental issues from ever having guns again. I think that's overbroad. Sometimes people go through a mental health episode or issue and then they get treated and they get better. 10, 20, 30 years down the road, those people should have a route to restoration. I think it's really good that somebody's finally addressing that. It does make for strange bedfellows, but I think it's good, actually. That says something nice.
10 seconds, real quick. And again, I think this is another example of where, just depending on how we talk about the issue, we may seem very far apart or not far apart at all. I don't think the disagreement is over whether, to go back to the zero tolerance policy rule, whether there are some flagrant violations of those regulatory schemes. I'm like, yeah, if you're selling guns out of the back of your truck and just not running background checks, yeah, that's willful, right? But it was the way that the Biden administration redefined what it meant to be willful. There were some aspects of that I thought were inappropriate measures of what actually is or is not showing willfulness. And some of it, I think, was just to make it easier to use, easier to define factors, even if those easier to define factors were further removed from an actual measure of willfulness. And that's really what we're disagreeing about. And depending on how you word that, you may be like, oh, like we're on opposite sides of the room, or we're just sort of, arguing about literally 3 sentences.
So it's time to move to the question portion of our event. We gave members of the Carolina alumni the opportunity to submit questions in advance, and I wanted to start out with one of them and then move on to questions from the audience. So the question that we received in advance was, would you explain the concept of gun owner responsibility in the context of the Second Amendment?
Well, so in the context of the Second Amendment, right, I still think that incorporates both an individual sort of like communal type of responsibility, but also sort of this question of what can the government impose, right? Because regardless of what the government does or does not do and does or does not regulate, I think it is very clear, just from a moral and basic philosophical standpoint, that when you are in possession of a lethal weapon, it comes with a bit of responsibility to not be a complete idiot with that gun, especially when kids are involved, especially when it raises questions of guns getting stolen and ending up in wrong hands. So I think it's important that members of the gun-owning community and people who are thinking about becoming members of that community and exercising that right. This is more than just the abstract of, oh, well, every right has a corresponding duty, and, maybe Canada will invade and I will have a duty to be called up to malicious. No, you have a duty as a human being to not be an idiot with your gun. And I think a lot of our national problems could be better solved if 10% more people were 10% more responsible with their guns a lot more of the time. Now that said, clearly there's a regulatory component to that. We've talked about how there is this corresponding duty, and I think this is still the case even under the individual rights theory. There is a corresponding duty inherent with militia service and sort of the collective use of those firearms. I think that's less what people are concerned about. And so we're dealing with, again, to talk about like weird historical contexts of a time in which our primary concern is not, hey, we're going to be called up for collective militia service and we need to have a well-regulated, meaning functioning militia, but how do we keep people from doing bad things with their privately owned guns in an individual context? And I don't think anyone, well, never mind, I've sat on panels where there might be people who would disagree with this, but I think most people would reasonably say, yeah, there's an aspect of the government telling you there are certain ways we're going to regulate your ability to use firearms. And that's what this entire discussion is. I'm going to assume this question was not, and now I want you to delineate where specifically in every case is that line is, because we will be here not just all night, probably all week, and then you will still find that we all have disagreements. But I don't think those two things are mutually exclusive, no matter how you look at it.
Joseph? Yeah, I'll just underline what I hear Amy to be saying. I think is exactly right. That on this issue, like so many other issues, like a lot of the limits, the things that govern people's conduct, are going to be non-governmental. I mean, like the norms that you are raised and inculcated with as a gun owner. Like when I grew up, I grew up with guns, and both my father and grandfather would have been horrified if I were to carry my gun into a coffee shop. Right? That would just be like absolutely violate the sort of gun culture norms that they were culture. They would tend to be irresponsible, and I would have gotten smacked around for it. But there are others who disagree and think like, no, actually open carry of that kind is important. That's a way to show other people that guns are not scary and that actually gun owners are not scary. And so over the last 10, 15 years, seen a big shift towards, in some areas, towards open carry in an attempt to normalize it. You might agree or disagree with it, but it's not a legal fight so much as it's a norm about what is and isn't proper and what is and isn't responsible. And sometimes that stuff ends up sort of bubbling through into doctrine, into constitutional law, but it starts with more kind of like around the breakfast table or sort of like face-to-face conversations. And I would say this is one area where like I presume nobody's against the concept of gun owner responsibility, and certainly even those who are more pro-regulation and those who are more pro-right still believe that if you're using your gun or you're owning a gun, you should be doing it responsibly. And gun rights groups, including the NRA, have long been involved in projects, like Eddie the Eagle is one example for the NRA, that are all about responsible gun ownership for kids and so on. It's like, let us govern ourselves through norms instead of the government stepping in.
Yeah, and I think you see this sometimes even with the way that, going back to firearm locality, right, and the locality of laws, even just the way that different states have framed, how we are going to incentivize people who are gun owners who might have children around them. How are we going to incentivize them to be responsible? You will have some states that have just said, figure it out, right? We're not going to tell you what to do. You have other states that have said, we are going to preemptively tell you that that gun must be locked up or else. And then you have states like Virginia, and this comes to a head because my in-laws, if you've seen the news, spent their whole night on lockdown because of a mass shooting in Fredericksburg that dealt with 16-year-olds who had access to firearms, and then we're going to sell those firearms in a legal gun deal that then went wrong. A lot of people got shot. Between that and there was a third grader who took their parents' gun, brought it to school, accidentally discharged it in a backpack. Right? Those parents have now been charged I presume there is a good chance that these 16-year-old parents might be charged, that the parents of these 16-year-olds might be charged as well. But the way that Virginia law does it is sort of this middle ground, where it says, we're not going to tell you preemptively that it is a crime just straight across the board if you haven't locked up your guns, but if you're wrong and your underage child is around these guns and gets access to them and uses them to harm someone or to endanger the lives of others, yeah, you're going to be on the hook then. So, you know, use your best judgment. Do you really want to take that risk? And it sort of empowers gun owners in a way to choose how to be reasonable and to weigh those risks. And so you see this sort of, again, just this spectrum of how states are balancing how much they're going to intervene to impose those levels of responsibility. And it's, again, I think just reflective of that broader discussion that you're seeing amongst just the general population.
So we have time for some questions from the audience. If you have a question, just raise your hand. Nora and Rory, I believe, are coming around with microphones.
First of all, I want to thank all three of you for really helping us to understand a difficult and complicated issue. And so thank you. I have a two-part question about the test from Bruin. Part of the court's justification for focusing on history tradition was that the court had been doing that, they said, in the First Amendment context. So my first part of my question is that correct? And then the second part of the question is, I know we lawyers like to think we're experts at everything, but I wonder whether lawyers and judges have the competence to do the kind of historical analysis that the Bruin test suggests is going to be so important going forward. I'm particularly interested, Matt, in your view on this as someone who has both a JD and a PhD. You know, is this something that we're gonna need to have PhDs on the court in order to do that kind of analysis? I mean, how is this going to work?
So, sorry, I immediately stole that one.
Go ahead.
Like, I'll arm wrestle you over here.
That's all right. That's fine. Different kind of arms.
So, to take the first part of your question about the Bruin test itself, I think, one, taking a step back, I think it's important to remember whatever you think about the Bruin test and text history and tradition, this was the test that both parties asked for. A lot of people forget the government in oral arguments was asked, do we go tiers of scrutiny or do we go text history and tradition? And the government said text history and tradition. Now, I am very skeptical. I don't think that's because the government was suddenly like, oh yeah, we're all originalists now, text history and tradition. No, I think they were terrified of getting strict scrutiny. And they felt that there would be a little bit more wiggle room with, and I think they're being proven correct with this, with text history and tradition. That said, I still think up to that point, there was a lot of, just a general feeling that the First Amendment sort of tiers of scrutiny framework would be very useful in a Second Amendment context. A lot of people have made that argument. I think things like time, place, and manner restrictions lent themselves to sort of easy implementation. But at the end of the day, this was what both parties asked for, I think for very opposite reasons. With respect to the second part of your question about what is this asking of judges, the reality is it's asking judges to do their job. They're not being asked to be historians in the sense that they're being asked to weigh facts of history, right? Was there a second shooter on the grassy knoll? No, that's not what they're having to determine, nor are they having to determine sort of historical value. Was it good, right, and salutary for the National Firearms Act to be passed? Their job is to take historical laws and analogize them to modern laws, which is right up their alley, right? It's not stripping them or removing them from that legal aspect of analyzing historical or existing laws. And I think in many respects, it's actually easier for judges than looking at some sort of balancing test, because when you look at what was happening in many of these lower courts under the two-step test, the pre-Bruin test they sort of developed, it really became, you needed a PhD in order to study political science papers, right? They were having to weigh this competing data and statistics about whether or not this actually furthered a compelling government interest. It was a battle of the studies, which in many respects is less tethered, I think, to an objective reality than something like, was there a law or not? Now I think this is weird for a lot of people because many of them had never thought to look at what were the historical laws, right? If you're a Second Amendment historian now, congrats, you're making bank, right? Now is your time. And so I get it, like it puts it into a very different context, but I think it is much more objectively tethered, in my opinion, to the actual role of judges, because it doesn't ask them to be poli-sci majors and have to go through these studies about gun violence, which they were having to do a lot of in order to do these balancing tests. I suspect you might disagree.
I agree on some and hard disagree on some other. I mean, I certainly agree with the point that the Second Amendment historians are putting new wings on their houses right now, serving as expert witnesses. But I see that as part of the problem. I mean, I think probably between us we could name that whole group. They could fit on this stage. There's probably 7 people, PhD historians, who study firearms law. It takes a long time to get caught up on the history. The expertise just isn't there, and it hasn't been. And maybe at some point it'll develop and it'll get there, and it'll be more like the court treats facts in other areas. I mean, the way I see it, at least, is that if the justices were just doing historical facts, as you described, then it may be less of a problem, but that's not it. Like, they're not actually disagreeing so much about the facts. They're disagreeing about the analogy point, and that's where all the judicial discretion tends to come in, right? Like Rahimi, we were talking about earlier, this is the one involving the guy with the domestic violence restraining order. Not a unanimous opinion. There's a dissent in that case, Justice Thomas, who wrote Bruin, dissents in Rahimi, not because there's a big difference on the historical facts, but because looking at the same laws, he just says, well, these two categories you've defined, surety and affray laws, don't look similar enough, right? That's just a level of generality question that, like, no amount of adding historical facts is going to change. I also think finding the historical facts is hard. I mean, I say this as somebody who has, over the last 7 years now, built a repository of historical gun laws, free online resource, you can use it. It's involved thousands of hours of effort to get from our initial set of about 600 laws to where we are now, which is 2,500. And the reason it's hard is because most old gun laws are not searchable on, like, Westlaw and other places where we would find them. Any of you who are history majors will know this. If you're trying to find, like, I'll use the Dodge City example again. If you want a copy of the Dodge City regulation, you got to send them $10 to the Historical Society, and they'll fax it back, right? And you get the sort of hard copy. That's to do that across the country is almost impossible. And so I think judges are operating with, like, not full information, not an ability to get full information, and although the Supreme Court can get away with that sometimes because they get great briefs, from people like Amy who are very teched up, the lower courts, especially the trial courts, are just at sea here because they have crowded dockets. They don't have access to these experts, even if the experts exist, right? They're trying to process cases. I was talking to a federal judge recently, appointed by President Trump, as a recent appointee, who said, it galls me that the justices have announced this test, and none of them, she's actually wrong about this, 2 of them, none of them have ever said the words, government, call your first witness, because none of them have been trial court judges. It turns out 2 of them have, Justice Sotomayor and Justice Jackson. Both of them dissented in Bruin, or Sotomayor did, and Jackson disagrees with it, because the test, I think, just doesn't work. I'll say the last thing, too, is that they're not treating these historical facts, these facts, the way that the legal system treats other facts. Like, the Bruin case is a good example of this, and this is a little technical, but Bruin, there was no trial in Bruin. There was no facts introduced below. The court took this case on what's called on a motion to dismiss, meaning there was no factual development below, no experts, no adversarial testing of anything. It's just amicus briefs and the justices and their own clerks finding out what history they want to find. That's totally different than we treat expertise in other areas, whether it's economics, medicine, science, of other forms. There, yeah, sure, you have experts come in, the judge weighs one or the other. Not seeing that as much in the Second Amendment cases. I think the expertise just isn't there, partly because it's just hard for these historical facts to speak to the kinds of questions that we have today with guns. So I would much rather see, frankly, like a strict scrutiny test than I would this, because this has just been, I think, chaos. Oh, on the First Amendment, I'm so sorry. You asked this, and I have to answer it because I guess especially like, the court the court points to the First Amendment, says, well, this is how we always do things in the First Amendment. This is wildly misleading. The best article that I've read on this is written by the person sitting next to you, Mary Papandreou. Highly recommend. But essentially, the court has been trying to reinvent its First Amendment precedents to look more like this historical categoricalism. And that project is ongoing, but at least right now, the First Amendment contains multitudes of tests, including some of those that Amy mentioned: time, place, and manner, intermediate scrutiny sometimes, strict scrutiny in other kinds. And I think that's maybe the sign of a healthy, mature doctrine. And maybe the Second Amendment will get there someday. Like, the First Amendment is not governed by one case in the way that right now the Second Amendment kind of is with Bruen.
Yeah. And also, I think that lack of framework, right, that to go back to literally the first thing we talked about the perception of time, in the perception that this is moving slowly, I think part of the problem with the difficulty is, like, it's this perception of, oh, this is unique to the Second Amendment. I think this would have been unique to any framework that is starting from scratch, where prior, just 15 years ago, it would have been, you look at the earliest assault weapons case, like when the Ninth Circuit upheld the 1989 California one. They were just like, well, Second Amendment doesn't apply to individuals, so yeah, do whatever you want, kids. Then you have, math, 14 years after Heller, 12 after McDonald, of sort of heightened scrutiny, I guess, where the courts do settle a number of these issues again. But now it's like, we're starting over with literally a framework that, I think we both agree, many judges have never thought about it in this concept before. And so part of this is just the perception of, well, it's chaos. Well, we would think that about literally any framework being built up from the ground. I have no doubt that there were times within the First Amendment sort of, just the years of building that up, that courts being like, what are we supposed to do with this test, right? Like, you've told us nothing. So I don't think that's unique. I just think it feels unique. That almost certainly does not change our disagreement on it.
But it does underline something really important. Like, the Second Amendment now is basically where the First Amendment was a century ago. And it would be unfair to expect that the Supreme Court or any of the courts had figured everything out. And so we will hopefully be getting more guidance. You guys should have us back in 10 years and see kind of where things stand.
And
on
honestly, we'd both be mad if the next Second Amendment case, the court was just like, yeah, so we just from on high, in a case that didn't make sense for us to do this, just settled all these random questions.
Can't do it.
Yeah, it's just not how it works.
Great.
Any other questions?
So my question is, do you believe the Supreme Court's reliance on historical traditions is a disadvantage when addressing modern challenges in firearm regulation?
Sorry, could you repeat? I couldn't quite hear.
Oh, sorry.
No, it's okay.
Again, everything. So do you believe the Supreme Court's reliance on historical traditions is a disadvantage when addressing modern challenges in firearm regulations?
I think one of the challenges, and you've heard us say a little bit about this already, I think one of the hardest things about relying on historical tradition is, and for resolving any of these cases, is just figuring out which ones to accept and which ones to reject, which ones are cautionary, which ones are confirmatory. Like, in my view, the problem with Bruen, I know I've been critical of Bruen, is that it asks too much of history, in my view. I think relying on history, relying on tradition is actually a time-honored way of interpreting the Constitution I fully support. It can be really useful to look to history and historical tradition to understand what some of the basic words in the Constitution mean. To give an example here, we were talking about the Rahimi case, which involves domestic violence restraining orders. The Constitution actually contains the words domestic violence. It's in Article 4, Section 4 of the Constitution. So you might look at that and be like, wait, what is this about Congress has to protect the states from domestic violence? History and historical tradition can help explain they're talking about essentially civil unrest, not intimate partner violence. That's to me, a good use of history. Where I find flaw, and actually even that's kind of what Heller does. Where I find flaw in the Bruen framework, I think is just asking the questions at too low of a level of generality, right? And so if I looked at the historical gun regulations, there's plenty that I don't like. I don't think that it's constitutional, nor is it morally correct to disarm people based on the color of their skin, or whether what their religion is, or whether they've taken a loyalty oath. We should obviously reject all of those. But if we reject those, then should we also maybe reject some of the historical silences, like the failure, for example, to protect especially women from intimate partner violence in 1791, right? Like, and once you start doing that, that picking and choosing, then it feels to me like you kind of cut loose from the history anyway, and that seems like you're back to some kind of scrutiny or considering what we call means ends analysis or cost benefit analysis or something like that.
Yeah, so I think looking at Bruin in a vacuum answers this question differently from looking at Bruin and what it will likely be after Rahimi. Because I think there were potentially ways of very narrowly reading Bruin that would have called into question, honestly, even the things that Bruin itself was like, yeah, we're not questioning shall issue laws anywhere. But then you run into the question of, well, under like a really restrictive reading of Bruin, why aren't you though? But I think Rahimi, in its sort of use of this intermediate, fairly broad conception of how to do this test, I think is instructive and helpful for understanding why I'm not super worried about it. And specifically its capacity to deal with modern problems. So they do pay lip service in Bruin to this idea of not just that we aren't looking for a twin or a dead ringer, but that also it leaves room for new situations, for applying these sort of base principles to changing technologies, changing scenarios, to types of, is just one example, like places that did not exist at the time. Things like, 90,000 seat sports arenas, right? That's fairly new in a way that courthouses, et cetera, are not. Airplanes, right, and TSA and all of those things. Again, it's going to take time to figure out where those lines are, and I don't know that any 5 justices have an agreement right now specifically on where all those lines might be for everything. Like, I think that's part of the theoretical disagreement here. But insofar as it's going to apply to things like background checks or permits to purchase, I think it's pretty clear that sort of the core of our modern gun control laws, at least our longest standing modern gun control laws in that basic framework, I don't think it was ever in danger under Bruin. I don't think it's in danger under Rahimi. And even if it were, I don't think the court is super interested in reading it that way, because I think it's going to continue falling back on this idea of just like the types of weaponry that we can own today and the types of weaponry that are protected are not limited to those at the time of the Constitution, right? I think the flip side also works for the government. You sort of saw this in Rahimi, this idea of the government itself can sort of use technologies to better apply its basic premise of protecting the public from dangerous people. And I think you're gonna see that with things like serial numbers, right, and background checks. To say that in 1792, anybody could have comprehended the technology to real-time check whether or not someone was prohibited, that it didn't exist. I don't even think they really, honestly, I think that would have shocked them more than being like, oh, it's an AR-15, it does the same thing but better. I think that would have been farther beyond their conception. I think the court has made it clear that it's not going to touch that rationale, that it's going to leave that buffer zone for ingenuity, really.
Well, I think that's all the time that we have for tonight. I want to thank both Joseph and Amy for being with us here tonight. A recording of tonight's event will be made available on our YouTube channel in the next few days, and there's pizza available in the lobby if you'd like to grab some on your way out. Thank you again.